As we've been reporting, Supreme Court Justice Stephen Breyer is retiring at the end of the court's term in June. To discuss, I want to bring in Kim Wehle. She is professor of law at the University of Baltimore School of Law. Thank you so much, Kim, for being with us on this momentous day. So Justice Breyer's potential retirement had been rumored and, frankly, encouraged by many Democrats for a while now. Tell us a little bit about the pressure that was on him to go ahead and retire, and how much did that have to do with his decision to leave now?
Well, impossible, of course, behind the scenes, not knowing what happened, but we all know that RBG, Ruth Bader Ginsburg, was also pressured, at least publicly, to retire in a moment where Barack Obama could have replaced her. And that would have changed the course of history, because we would still, in this moment, presumably, have a 5-4 conservative majority on the Supreme Court, putting Chief Justice Roberts in that swing vote that used to be occupied by Justice Kennedy. Why that matters, it's just like sort of, Congress wrangling a deal. It means that with a 6-3 majority, the conservatives don't need to get anyone on board from the more progressive end. They can push through pretty radical public policy decision, which is happening without being elected and without really having to make any deal. So Justice Breyer's, in this moment, I think his retirement is about replacing apples with apples. That is, it's not going to change the 6-3 majority, but it doesn't leave things open potentially for Joe Biden having to replace him closer to an election, or even worse, if the midterms put the Senate in Republican hands, he would not potentially have the votes to replace him later, as we saw with Merrick Garland, where Senate Majority Leader Mitch McConnell just stole essentially that seat from Barack Obama, refused to even give him a hearing, which of course was not the Senate Majority Leader's prerogative under the Constitution. It was Barack Obama's prerogative, but the president in that moment didn't push back.
So, Kim, the contours of Justice Breyer's anticipated formal announcement, we've got this sort of understood preparation for an announcement, is that he will step down from the court at the end of this current court term, which expires in June. What are some of the key cases on that docket?
Yeah, Major, I think the fact that he's waiting till the end of this term is critical. I would guess that's a pivotal part of his decision, because we've got the three biggies. We've got religion, abortion, and guns on the court's docket. When I say they're biggies, because these are not black and white legal issues. These are really social issues. This has to do with our cultural norms and how we want our country to function going forward. Of course, already this conservative court has thumbed its nose on precedent with Roe versus Wade in allowing what most experts will say is a blatantly unconstitutional law in Texas to go into effect pending the full ruling on it. And I say that because Roe is still the law of the land. It protects abortion rights until 24 weeks from government interference. And the Texas case, that law interferes at 6 weeks. So that's number one. Number two is it has on its docket a question of whether the Second Amendment protects your ability to carry a gun outside of the home. All the court has said so far is that you can have a handgun in your home for self-defense. But the question is, can states regulate guns outside the home? If the court holds that unconstitutional, we will see the inability of even progressive states potentially to regulate guns outside of the home. The last piece has to do with the separation of church and state, whether the court involving a case in Maine will hold that taxpayer dollars have to go to schools that teach religious doctrine, not just schools that are using taxpayer dollars to repave a playground in a neutral way, but there are two highly conservative, really Christian right-wing schools that teach things like anti-LGBTQ rights, for example, whether the government, if they're going to give money to schools, has to also give money to those kinds of schools, which would wipe out this separation of church and state potentially in ways that significantly affect the American public. I don't think Justice Breyer's vote's going to make a difference, but he probably in his swan song wants to be part of having his voice heard on those three pivotal issues.
Yeah, it is just a momentous Supreme Court term. Kim, talk to us about Justice Breyer's legacy. What are the history books going to say about Stephen Breyer?
Well, Nancy, I think what's interesting about Justice Breyer is, as much as he's kind of sort of put in the progressive camp, he's actually fairly moderate in terms of his judicial philosophy. We heard a lot with Amy Coney Barrett about this notion of originalism or textualism, reading the Constitution black and white between the lines. Of course, that's actually impossible. It's an old document. It's like a poem or a biblical text. Justice Breyer sort of was in the middle. He said, listen, we start with the text, but we have to be very pragmatic and practical about people's lives. So he tended to ask hypotheticals that were very common sense, almost like you're talking to a school, a classroom of 7th and 8th graders using that rational common sense. He didn't author any major sort of groundbreaking opinions. He came out for weighing heavily women's interests when it comes to abortion. He was also, concerned about the death penalty and things like, lethal injections that would be inhumane. But I think he's going to be seen as a pragmatist and a moderate. And we can see this even now, even with these two, Justice Kavanaugh and Coney Barrett and also Gorsuch, 3 recent justices put on the court with no filibuster, no progressive or Democratic buy-in across the country. And we have Justice Breyer around saying, listen, we're not politicians in robes. We really are, an institution of legal minds that call balls and strikes. And unfortunately, I can't agree with him anymore on that. But the fact that he's still using that refrain, I think, shows how much more moderate he is than some of the justices might be considered today, the newer justices.
So, Kim, I want to ask you about something that might be part of the Breyer legacy. He described what he called the 6 interpretive tools in making judgments while he was on the high court. He said those tools are text, history, tradition, precedent, purpose of a statute, and the consequences of competing interpretations. He said only in the last 2 does he really separate himself from so-called textualists on the court, meaning those on the more conservative side of the ideological spectrum. Do you anticipate whoever fills Justice Breyer's seat will embrace those? Do you think they're still relevant? Do you think those 6 tools are really basically consistent with what a modern Supreme Court justice ought to do on the bench?
I do, Major, and I think it's actually those are the tools that any justice should use. I don't know that there's any justice, even on the progressive end, who will sit and say, listen, I want to make up my own Constitution. They will all start with the text. And then if the text is unclear, what's a reasonable search? That reasonable is a very squishy word. It depends on points of view. Then you might look to old texts from back and when the Constitution was ratified, and then you're going to pay attention to practical implications. I think whoever replaces him will go through those same paces. The difference is the conservative justices will say, I don't actually look at the pragmatic implications, but they do because they have to, because this language is so vague and so old.
Well, it'll be a fascinating couple of months in Washington for sure. Kim Wehle, thank you so much for bringing your insight and expertise to the discussion.
Thank you for having me.